This video will discuss the factual background and the important holdings of the case Attorney General and Guardian Newspapers Limited, No. 2, otherwise known as the Spycatcher case. First of all, let's begin with the facts. From 1955 to 1976, Peter Wright was employed in a senior capacity by counter-espionage branch of the British security service known as MI5. In that capacity, he acquired knowledge of many matters of prime importance to the security of the country. Following his retirement from the service, he went to live in Australia and later formed the intention of writing and publishing a book of memoirs describing his experience in the service. He wrote the book and it was accepted for publication by Heinemann Publishers, the Australian subsidiary of a well-known English publishing company. The Attorney General, in right of the Crown, learning of the intended publication of the book, instituted in 1985 proceedings in New South Wales against Mr. Wright and Heinemann Publishers, claiming an injunction to restrain the publication in Australia, or alternatively an account of profits. Pending trial, Mr. Wright, the publishers and their solicitors gave undertakings not to reveal the contents of the book. The Attorney General's action failed before Justice Powell and again before the Court of Appeal of New South Wales. Special leave to appeal was granted by the High Court of Australia, but the respondents were released from their undertakings. So the book was published in Australia on the 13th of October 1987 under the title of Spycatcher. On the 2nd of June 1988, the High Court dismissed the Attorney General's appeal upon the sole ground that an Australian court should not accept jurisdiction to enforce an obligation of confidence owed to a foreign government, so as to protect that government's intelligence, secrets, and confidential political information. Therefore, it can be said that a duty of confidence arises when confidential information comes to the knowledge of a person, the confidant, in circumstances where that person has noticed or is held to have agreed that the information is confidential, with the effect that it would be just in all the circumstances that that person should be precluded from disclosing the information to others. For example, there would be no point in imposing a duty of confidence in respect of the secrets of a marital bed if newspapers were free to publish those secrets when betrayed to them by the unfaithful partner. Putting this in perspective, when trade secrets are betrayed by a confidant, it is usually the third party who exploits the information, and it is the activity of the third party that must be stopped. It was stated in the case that the principle of confidentiality only applies to information to the extent that it is confidential. In particular, once it has entered what is usually called the public domain, then as a general rule, the principle of confidentiality can have no application to it. It is said that information enters the public domain when the information in question is so generally accessible that in all the circumstances it cannot be regarded as confidential. Given that a duty of confidence precludes disclosure to others and a third party, such as a newspaper, with confidential information is similarly bound by a duty if they know it is confidential. This was true unless the duty was known to the general public, or was outweighed by a countervailing public interest. The Attorney General had to show that disclosure was contrary to the public interest. Because Spycatcher was already published worldwide, the injunctions were not necessary, nor available. The articles in the Observer and Guardian contained no damaging information, meaning no breach of confidentiality. However, the Sunday Times was in breach of its duty of confidence. It was not protected by a defence of prior publication, and the fact that the story was to be published imminently in the US made no difference. It was therefore liable for the profits it made. However, no further injunctions were to be granted on this matter. Thus concludes my video. My name is Sam Turner, and thank you.